God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here this morning. Before we call the first case, I want to go over some of our procedures just so everybody's on the same page before we get started. I'm sure that most of you are very much aware of it, but no, I don't think there's any harm in repeating it. First of all, each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, the proper method to do that is after you've introduced yourself to request that from the court before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. Obviously, appellee gets no rebuttal time. In order to aid the attorneys making the argument, we have a lighting system on the podium. We believe it to be rather straightforward. There are 3 lights on the podium, green, yellow, and red. So long as the light's green, you've got plenty of time. Once a light turns yellow, you're running out of time, and once a light turns red, you are out of time. And we ask that you please respect those time constraints. If there's more than one attorney going to make an argument, then the court expects you to divide that time by agreement, and before you begin your argument to make that announcement to the clerk so that she can set the timer appropriately. One very important thing, and I think perhaps it's the most important thing, is these arguments are being live streamed. The reason I say that is once you've said something here, you can't take it back because it's out there. So think about what you're saying before you say it. We've seen people be embarrassed before by something they've said, and obviously don't want you to have that same experience. Your panel this morning consists of Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
BNC Adams versus Buchanan D. Dunavant et al.
All right, we shall hear from the appellant.
Good morning. My name is Will Rout, and I'm here for the appellants, the law firms.
All right, sir.
And I would like to reserve 3 minutes for rebuttal.
3 minutes. All right, sir.
So this case is an action in interpleader. The dispute arises out of the parties' claims to certain funds that were distributed from trust for the benefit of Buchanan Dunavant. So in fact, in our position is that we, the firms, were entitled to receive a legal fee and expenses from these trusts that are at issue, pursuant to a fee agreement that we have with Mr. Dunavant.
Pull that microphone down a little bit, please.
Yes, sir. Mr. Dunavant agrees. This is reflected in 2 sworn declarations that he's filed with the probate court, and they're included in the record. There's nothing in the record to contradict Mr. Dunavant's testimony. Instead, appellees obtained an unlawful injunction on the distribution of these funds and ultimately obtained the funds due to errors committed by the probate court. Fundamentally, we contend that the probate court failed to follow Tennessee law and the rules of civil procedure. It began when the probate court unlawfully enjoined the distribution of the trust funds to Buchanan Dunavant. The injunction was unlawful both because there was an adequate remedy at law, which is money damages, and because the trust contained spendthrift provisions, which would prevent such injunctive relief. The court is well within its rights to reverse on these grounds alone and require the appellees to return the money for distribution in accordance with the terms of the trust. However, because the probate court...
Let me ask you a question before
Yes,
we get
sir.
too far into this. Was an evidentiary hearing ever held in any of these matters?
No, sir.
How were the matters determined without evidence? Were matters stipulated, or were agreements presented to the court? Or
The court, typically at status conferences, simply ruled. We didn't have the opportunity to provide evidence. We didn't have the opportunity to call witnesses. In fact, in this interpleader matter, there's four probate cases that this arises out of. But when the interpleader was filed on November 29th, we filed a conflict, a Rule 10b challenge to the judge on December 6th. On December 7th, he simply ruled. He granted the interpleader in its entirety without even allowing us to answer, without letting us present defenses, without hearing any evidence whatsoever. So we just contend that, this was entirely an error.
So no evidentiary hearings?
That's correct.
Okay. And your purpose in the interpleader action was to reach the funds, I'm assuming?
That's correct. Yes, sir.
You're claiming some type attorney's lien?
We are. So we have a contract with Mr. Dunavant that essentially we would represent him in an underlying case. He brought a case against his father in Dunavant versus Earhart. His father had a contractual obligation to provide an irrevocable life insurance trust for him, which was never done. We at least allege that was the case. It's come up through the Court of Appeals, and we're currently probably going to appeal that to the Supreme Court. But
let me ask you, how do you get a charging lien in a case where you didn't represent and were not involved in that case at all? I mean, you got to be familiar with the charging lien statute, and it provides for a lien in cases where you represent a party.
Our lien is based on our contract with Mr. Dunavant. So we were entitled
If you've got a contract with him, in order to collect from him, wouldn't you have to file a separate lawsuit?
I don't think so, Your Honor. I think that under the terms of the contract, we were entitled to receive these funds. They were set for distribution. Then essentially the probate court entered in what we contend is an unlawful injunction on the distribution of those funds.
And why do you say it was unlawful?
Well, because, so that was filed in those underlying probate cases.
Right.
And those cases, essentially the plaintiff alleged that our client, Mr. Dunavant, mishandled certain trusts that he was the trustee of. So.
And he agreed in the settlement that the funds that would due him from those trusts would be paid to those parties that brought the action against him. Is that right?
And his contention now is.
Well, I don't mean now, but then when he entered into the agreement, he agreed that those funds could be paid to the other parties.
He did.
Is that right?
But his position now is that he entered into that only because of the financial distress caused to him by the injunction, which never should have been entered in the first place, and he's now trying to rescind the settlement agreements.
Would that be a basis to set aside the agreement that he entered into with the advice of counsel, didn't he?
Yes, but the agreement was contingent upon essentially our liens being satisfied. They haven't been, so I think that it can all be set aside.
Now, as I understand your argument, you say the trust involved includes spend-thrift
That's correct, Your Honor.
provisions. And so, to the extent that it includes that, as a creditor, and that's what you're claiming you are, how would you get access to those funds? Because they're not available to creditors.
They're not available to creditors, but what it does prevent is the probate court from putting an injunction on those funds before it's distributed pursuant to the trust. And Mr. Dunavant's instructions to the trustee were to pay those trust funds into our escrow account for distribution according to his contract with us, and then according to the trust thereafter. So without that injunction, those funds should have been distributed to our escrow account. Then we would have taken what we are owed under the contract, and the rest would have gone to Mr. Dunavant.
Let me back up a little bit on Judge Armstrong's question. Your lien is by contract, correct?
That's correct.
And what efforts have you made to collect that?
Well, we've asserted the lien in probate court. I mean, one of the big problems in this case is that every time we've been before the
Are
probate
you
court.
agreeing probate court has jurisdiction of your lien?
I'm sorry, I didn't hear that, Your Honor.
Are you consenting to probate court having jurisdiction of your lien as far as you can consent?
Well, we aren't consenting to the extent that we don't think the injunction was lawful in the first place.
Let's forget the injunction. Let's
Okay.
talk about the lien right now. So are you agreeing that that's where you're going to live and die with your request for attorney's fees?
At this point in the case, I believe so.
Okay, so
But-
you're not challenging the jurisdiction of the probate court to determine your lien.
Correct. However, we have,
Is that consistent with your brief?
well, it's consistent with our brief in the sense of what I was already saying, which is that, you know, we don't believe the injunctive relief was proper in the first place.
Let's don't talk about the injunction for a minute. I'm just trying to figure out how you have standing to do anything.
Well, we have standing because, I mean, I can't separate this from the injunctive relief. Our standing is based on the fact that
You've got to establish that you've got a right to funds first.
well, the fact is the probate court exercised jurisdiction over the money and then exercised jurisdiction over us.
But are you challenging the authority of the probate court as to your lien or as to jurisdiction over you?
Yes, in that sense.
I thought you just told me you agreed that the probate court had jurisdiction.
Well, you were setting aside the injunctive relief. What I'm
Yes,
saying
I am,
is,
because that's I
If
get
the-
to ask the questions, and that's my question.
if the probate court has taken jurisdiction over the money, we have to be there. We do challenge that. We don't think that was proper. We think that was unlawful. So that's why I'm saying I can't separate it from the injunctive relief.
Well, okay, let me ask an easy question then.
Okay.
You say you have a right to a lien by contract. What efforts have you taken outside of the probate court to establish your claim?
Well, we filed our notice of lien in both circuit court and probate court, and we have attempted to litigate this through the probate court, but of course, at every effort, we haven't been given the opportunity to have evidentiary hearings. We haven't even been able to answer in the interpleader until after, you know, until after the court ruled that the interpleader was granted. So we just haven't been given the process to do that. We always appear at a status conference and he'll just make a ruling, and that's that.
Did I hear you say you filed a charging lien both in the circuit court case and in the probate court case?
That's correct, Your Honor.
I guess I'll go back to my original question. What would give you authority to file a charging lien in the probate court case? I understand the circuit court case because that's where your client represented Mr. Dunavant, but not in the probate matter. So looking at that statute, what would give you authority to file a lien in the probate case?
Well, it's based on the contract, but it's also based on the fact that at the time it was filed, the circuit court had essentially said that the money that would come from this trust would be essentially damages against any damages against his father in the circuit court case. So it would offset any damages that we proved in the circuit court case. So in that sense, we had at the time both the contractual lien and we had a charging lien in the sense that those trust funds specifically were set aside as damages to offset anything else that was proven in that case.
Let's assume you filed a separate lawsuit to try to collect your fee. Could you have attached those funds out of that trust that has the provision that prevents really claims by creditors? How would you have collected from those funds?
I'm sorry, I just missed the question, I'm sorry.
Well, it's part of the argument you made earlier that no injunction should have been granted.
Yes, sir.
Because of provisions in the trust that would prevent that. So you argue, well, if you got a judgment how would you be able to reach those funds because of the provisions in the trust that prohibits claims of creditors from collecting from the trust funds?
Well, I mean, once the trust funds are distributed, they would be paid. In fact, Mr. Dunavant had ordered those funds to be paid into our escrow account so that we could take our fee and then pay him. But even if they were paid directly to Mr. Dunavant, I mean, we would have, if there was some kind of disagreement, a contract claim. But there's no dispute. It's in fact, the record here establishes there's no dispute about that.
All right, thank you, sir.
Thank
Got
you.
your rebuttal time.
I'm going to split time with Mr. Alpert, and I'm only going to take 4 minutes, and then I will turn it over to him. Thank you. I will try to be brief, but I'll be happy to answer any questions you may have. May it please the court, I am Lynn Thompson, and I represent Ben C. Adams, Jr. as the trustee of the William B. Dunavant Irrevocable Life Insurance Trust and the Dunavant Sprinkle Trust, both dated, first one dated 1984 and the second one in 1991. I have made, my argument is limited to the appropriateness of the interpleader that was granted by the trial court on February 19th in 2023. It's February 13th. And I assert on behalf of the trustee that the order granting the trustee's interpleader on February 13th, 2023, that the trial court did not err in granting that, despite the fact that they did not have a hearing. The trustee filed their interpleader action on November 29th of 2022. 10 weeks later, it was granted by the court. The portion of that order that approved the trustee paying the funds into the clerk of the court, as well as releasing the trustee from liability, we believe was not in error because no one had filed any, in that 10-week period, nobody had filed any objections to the interpleader. The Buck Dunavant had, in September of 2022, entered into a settlement agreement whereby Buck Dunavant agreed and directed the trustee to distribute $811,000 from the trust to the benefit of 4 trust or accounts for his children.
Let me ask you a question there, because I'm trying to figure
I'm
out.
sorry,
Oh, I'm sorry. I mean, here, I'm a bit confused, just to be honest. I realize that there are other cases, 3 or 4 other cases, making their way through the appellate process regarding the appropriateness or the validity of the settlement agreement with the wife, former wife, and children. Is that an issue for us in this case? Because we seem to be bouncing back and forth.
I do not believe that it is in terms of my argument, because my argument is limited to the appropriateness of the interpleader. When Buck committed to, by executing the settlement agreement that directed the trustee that you can pay these, the $811,000 to these 4. The Ben Adams' duty as trustee was to Buck Dunavant and to pay the money to Buck Dunavant that was left to him from these trusts, or at the direction of Buck Dunavant. I did make an error. I've got 51 seconds left. He had paid $100,000 directly to Buck via the Watson Burns escrow account prior to any of this starting. So that's where the first money went. Then the trustee was directed, pursuant to the settlement agreement, to pay the $811,000. Then the appellant law firms came forward and said, no, wait a minute, we need $600,000 of that, which put Mr. Adams in a position that Rule 22 was made for. He's holding money that doesn't belong to him. He's got claims that exceed the amount of money he has. We filed the interpleader and asked to be released. I believe that the interpleader was appropriate, and I also would ask you to look at the case decided by this court in 2018, the case of CNC North America, Inc. versus Natural Stone Distributors, cited in my brief. It is at 571 Southwest 3rd, 254. It states that if the party, in this case the law firm, fails to object to an interpleader action, that a later objection may be waived if that party proceeds to argue the merits of their competing claim, which the law firms did. So we believe not only was the interpleader right on its own stand, but the law firms have also waived their right. Yeah,
let me ask you, the spendthrift provision in the trust, would
I'm hard of hearing in this environment. I appreciate it.
Okay.
Thank you. I've got my hearing aids turned all the way up.
You know there's spendthrift provisions in the two trusts. Is there anything about those provisions that would prevent Mr. Dunavant, Buck Dunavant, from agreeing to have those proceeds that he was entitled to be paid to others by his settlement agreement?
No, the spendthrift provisions come into play when you talk about the TRO, and we, the trustee, said we've got a spendthrift provision here, creditors aren't entitled to this, and that was an issue for the trustee until Buck signed the settlement agreement, because what we perceive that to be is at Buck's direction.
Right, and not a claim of a creditor.
With his approval.
Okay, all right.
Thank you.
Good morning. May it please the court, I'm Jeremy Alpert from Memphis with the Clankler Brown Law Firm, and I represent Douglas Dunavant as guardian for two minors, and then Lillian Gardner Dunavant. And these Dunavant appellees asked the court to affirm the trial court in all respects.
Well, then you would be the perfect person to answer the question about is the validity of the settlement agreements at issue in this appeal.
No, it is not, Your Honor. So this appeal is about the interpleader, and it is our contention, as we've briefed, that the issues in the what we call the 4 original probate cases are not before this court. And in fact, those cases have been settled. All issues were waived by Mr. Dunavant when he signed the settlement agreements, and he's the only party to that case other than the Dunavants who has even the right to appeal. The law firms who are now before Your Honor were not involved in those cases. They didn't represent Buck Dunavant in those cases, and they weren't parties to those cases. They have no right and no standing to contest the validity of that, if Your Honor please. So I hope I've answered your question that absolutely not. Those are not before the court.
As clearly as it could be answered today.
Thank you, Your Honor. I think it's important here for me to reset the narrative a little bit. You're hearing from the law firms that they're portraying themselves as somehow they're victims here, and they're not. This is a very different case than what the law firms portray. This appeal, indeed, the entire reason we're here today is because the law firms came down to probate court and asserted a lien that simply doesn't exist. That's the fallacy here, that the entire case is based on that fallacy. We have a lien, therefore we're entitled to money, and that's what caused Mr. Adams to have to interplead the funds in the first place because of that competing claim.
Do they have to have a lien, or can they just be a creditor or an alleged creditor?
Well, in my contention here, they may be an alleged creditor, but I think Your Honors have hit exactly on the issue. They've done nothing whatsoever to attempt to collect on that alleged contract that they have. By the way, a contract that no one's ever seen and that they've never produced. But for their coming down to probate court and asserting this lien, there would have never been an interpleader in the first place. And so in that respect, I think we need to make sure we understand This is not the case that they've alleged here. And also, I want to answer a question that was asked earlier that I don't think was fully answered. There was a hearing in this case on October 12th, 2023. If you look at the transcript of that record, of that hearing, which is in the record in this case at volume 33, and you'll see it's about 150 pages long. Buck Dunavant testified at that hearing, and you'll note in the transcript, I believe, from doing this from memory, that the court noted on the record in the transcript and in its order that was issued the very next day that the law firms did not put on any proof and did, in fact, chose not to put on any proof at that hearing for reasons I can't necessarily explain. So I think that hopefully answers that question. I think we've already covered the fact.
Is the probate court the proper forum to determine the claim of the law firm?
Well,
from your perspective.
From my perspective, the law firms should have never come down to probate court in the first place. The problem is, once they did, the probate court had to do something to be able to effectuate the settlements that had been made. And I understand we're trying to avoid that issue, but the problem is the probate court ordered the settlements to be paid when the court accepted those settlement agreements between Mr. Dunavant, Buck Dunavant, and his children. And so he ordered Ben Adams, pursuant to Buck Dunavant's agreement, to pay those funds. But Ben Adams couldn't or wouldn't because the law firms continued to threaten Ben Adams with suit if he followed the court's orders. So that was the problem. And that's why the interpleader had to be filed in the first place. So while do I think they should have filed in probate court? Absolutely not. But do I think the probate court had to dispose of the case once they came down there and asserted the lien? Yes, I think he had to do something with that issue to be able to get Mr. Adams to distribute the funds. Otherwise, the original cases could never be dismissed.
And you've answered the question a couple of ways, but the real way is there a valid exercise of jurisdiction by the probate court as to that lien in the position of your client?
I think the answer is he had to, yes. I think once the claim was made, and mind you, the interpleader made all of us defendants in that case. The folks that had competing claims became defendants in the interpleader that was filed. So I think at that point the court had jurisdiction and the ability to determine who had the rights to the funds, and I think he did that.
By necessity?
By necessity. Because, again, I would assert that the law firms came down and asserted a claim of lien that, in my opinion, and as I will explain, doesn't exist. But all their claims about the TRO and an injunctive relief, those are not before the court. I think I have answered that question. But let's talk about the lien that they've asserted. Your honors know there are two types of liens that can be asserted by an attorney in Tennessee. One's a possessory lien, it's a retaining lien, and one's a charging lien. There's no issue about the retaining lien here. We've all discussed it. It's a charging lien. And if you look at the statute, it's 23-2-102, 23-2-103, that's the statute. And it talks very specifically that the lien attaches to proceeds flowing from any judgment obtained on a plaintiff's behalf as long as the lawyer secured that judgment for the client. The law firm's lien, and you can find it in the record, volume 1, page 38, their lien in this case says they explicitly cite that statute and they call it a charging lien. But the problem is it doesn't meet the criteria for a charging lien because no judgment exists. They lost the circuit court case. They lost it at the circuit court level and they lost it before this court. Judges Stafford and McGee were on the panel that issued its decision on September 17th of this year, affirming the dismissal of that case from circuit court. So there's no recovery in the circuit court litigation that allows them to assert a lien for the services that they rendered in that case. So the funds held by Ben Adams and Interpled were not a judgment that the law firm obtained because the law firm obtained no judgment. And that's where their case here, in my opinion, falls apart because the entire basis of the claimed lien relates to the representation of Buck Dunavant in circuit court. The trial court and this court dismissed that case. So there can't be a judgment in that litigation. So no lien rights can exist by virtue of the statute. And so also to a point that Judge Armstrong made earlier, there are two requirements to enforce your lien rights. Requirement one, the trial court where the services are rendered has to declare the existence of the lien. And step two, the attorney must commence a separate action against the person who owes them the money to enforce that lien right. Neither of those things happened in this case. The law firms didn't go to the circuit court and ask the circuit court where they rendered the services to declare a lien, and then in turn, they didn't file an action against their client to try to enforce those lien rights. Those things never happened. So they should have never interfered in probate court in the first place. They should have never been there. And so now, what they did midstream, in the middle of this litigation, they realized they had a problem because they don't have a judgment. So they changed their strategy and they started saying, no, despite me filing a charging lien, it's actually a contractual lien. So we're not calling it a charging lien anymore, we're calling it a contractual lien. Lots of problems with that. Number one, where's the contract? There is no contract in this over 4,000-page record that's before this court. There is no contract. So they're trying to rely upon a document that's not on the record. It's never been produced. We tried to subpoena it. They refused to produce it. So they can't base a claim on a document that's not on the record. There's no such thing as a attorney's contract lien. It's either a retaining lien or a charging lien. That's what the law says. That's what the cases say. And more so, as we've already established, they haven't done anything to perfect it. They've done nothing to present a supposed contractual lien. Now they say, well, it's privileged, so we don't have to produce it. But that's not true. Privilege doesn't apply to an engagement agreement, and they know it's not privileged. There's an entire body of law that says fee agreements aren't privileged for the purposes of proving what that fee agreement was. In fact, the law firms, the Watson Burns firm, were involved in a case in 2009 where there's a decision from Judge McCullough that says fee agreements aren't privileged. So they know that, yet they're still asserting that claim. So beyond the fact that we assert there are no lien rights, there's nothing to discuss, the rest of what they argue, the TRO, the issue of the spendthrift provision, those aren't before the court. Those are issues in the original probate actions. They're not parties to those. They don't have standing to argue about that. And more so, when Buck Dunavant, who was the defendant in those cases, settled those cases, the cases are over. His rights to contest that are over, and there's nothing else to discuss about that. And what's I don't really understand is these lawyers who represent Buck Dunavant in a different case want to overturn the settlement that he made. And you know what the reason he made the settlement? Because he was about to be held in contempt of court by the probate court for refusing to account for all the funds that had gone missing under his watch. And so what happens is if the settlement gets overturned, Buck Dunavant goes back to facing a contempt charge. So that's the conflict position that they've got, and no one wants to talk about that. And this issue about failing to give notice and other things, they weren't parties, they weren't entitled to notice, and in fact, you'll see in the record in our brief, they didn't tell anybody about their lien claim until after the TRO was issued. So how were we supposed to give them notice? We didn't know who they were. I'm running out of time, so I'll just say, we ask the court to affirm the trial court in all respects. The law firms are not victims here. There's a settlement between Buck Dunavant and their children. The settlement was enforced by the trial court, and the trial court correctly ordered that the funds be paid to the children as Buck Dunavant agreed and instructed Ben Adams.
Are there any remaining issues in this case?
In this case?
Yes.
I believe not, no, Your Honor. If you look at the final order there was an order, I believe, on October 13th of 2023 that disposed of the funds. Now, Judge Townsend, I will admit, and you'll see it in the record, so I don't want there to be any confusion, he did ask that there be motions to revise filed, and those were filed and argued, and no, frankly, and that was argued back in March of 24, we don't have a decision on that. But I think at this point, now that we're here, and actually we filed a motion to dismiss this appeal because there was still an issue pending before the trial court. And the
issue pending is what? On the
this
motion
to revise that the law firms filed and that we opposed. Basically asking the trial court to set aside what it had done in distributing all the funds. But I think at this point...
Isn't that a motion to alter or amend?
Yes, probably, but that's what he called it. He called it a motion. You'll see it in the record. I think it's in the record at volume 31 or 32. But all the funds are distributed. And so I think if this court says, we affirm the distribution of the funds, yes, I think the case is over, and there's really nothing else to discuss, and I think the parties go on until you hear from us again about the other appeals.
Is there some reason that you're aware of that the trial court hasn't ruled on that motion to alter or amend?
I'm sorry, I can't speak to that.
I'm assuming it was timely filed.
There was a scheduling order, actually, that's, I believe, in the record that was required, that they were supposed to file their motion by a date certain. We filed a response by a date certain, and we had a hearing on end of March of '24.
Did the trial court reserve ruling on the amount of the appellant's fee?
No, I think when you say the trial court, you mean the probate court, not the circuit court where they supposedly earn the fee.
Probate court, yeah, we're hearing the probate court case.
Right. So, no, I would say the trial court didn't reserve any ruling on that. I think the trial court said you haven't, A, there's no contract, B, there's no lien, and there's really no fee to set. And so, and if you look at the transcript and the order from October 12th of '23, they didn't submit any proof at that hearing. So there was nothing for the trial court to really rule upon. They just decided we're not going to submit any proof at this hearing, and so the trial court did what it did.
And then you went in and argued your motions to alter or amend in the spring of this year?
We did. It was March.
Okay.
Yeah, I realize that's sort of hanging out there, and I hate that it is, but I mean,
It's problematic.
I can't deny what the record says, and I don't want to
Certainly, and I
misrepresent to the
appreciate you
court that issue's there. But I think, frankly, I would submit to your honors that it's moot. And I understand it's problematic, but I submit that it's moot at this point. We're here, and the funds have been distributed, and the court has already, here's the way I see it. I already filed a motion asking the court not to continue here to proceed until that issue was resolved, and the court denied that motion. This court did. And so in that respect, I took that to mean that the court felt that because it's an interpleader action and because the funds had been distributed, that this court felt like the issues were now resolved. And so in that respect, that's how I understood it when the court did that. And I would say, enough ink and enough oil has been burned on this case and the other cases that I would ask the court to not make us go back and not make us come back here for a second appeal on that issue. I just think at this point that issue is moot, and I hope that we can move on.
At paragraph 10 of the order, the trial court says,
I'm sorry, Judge.
it's assuming jurisdiction over a petition for attorney fees of the firms related to services rendered to Buchanan, Dunavant, and the circuit court case.
Yes, he did say that.
And he hasn't decided that, right?
I think he has. I think the October 13th, 2023 order resolves that when the law firms refused to put on proof that day. I apologize, Your Honor. What date is the order you're looking at?
That's February 13th,
Right, and that's February
2023.
13th of '23. So there's a subsequent order on October 13th of '23, and I think that resolves that because there was a hearing on October 12th, and that hearing is where the law firms didn't put on any proof. And you'll see Buck Dunavant testified at that hearing for his lawyer. So Mr. Walker's not here today for the Harris Shelton firm, but they had asked for their fees to represent Buck Dunavant at that hearing. Mr. Dunavant actually testified telephonically at that hearing. You'll find in the transcript. Again, I think it's at volume 33 of the record. So there was a hearing that day. Proof was put on by people who were asking for funds, and the Harris Shelton firm was awarded a fee of $44,000. So these lawyers certainly could have asked for whatever they wanted pursuant to that. And so I think the subsequent order resolves that issue.
So the probate court could make a determination about what fee they were entitled to in connection with their representation in a circuit court matter?
I think what he was trying to do was resolve the lien claim. And not,
Well, to resolve the lien claim, he didn't have to weigh in on what fees they were entitled to. He could just say, you don't have a charging lien, and that would be the end of it.
I understand. I didn't write the order, so I can't speak to his mindset, as you can understand. But I would tell you that I think the issues are resolved at this point. I think that's what he was trying to do, was resolve the lien claim.
And at that time in October, when you had your final hearing, that's when the judge directed the parties to file a motion to revise, as he called it?
You're going to test my memory on the record, Judge McGee. I don't think that is when he did that. I think if you look at the record, I believe it's going to be subsequent to that, that he decided he had some loose ends, so to speak, to wrap up based upon arguments that the law firms had made. And I'm sorry, I don't remember the date of that, but you'll find it in the record.
That's fine. This is all just a bit confusing
I
as far as the
understand.
procedure.
Well, but we lived it. I do understand, but I would submit again. I believe the case is resolved if we're correct that they have no lien rights. I think that's what's important here, and that's what I want to leave you with. If they have no lien rights, there is nothing to discuss. There is no dispute. There is no conflict. There are no competing claims. So if we're right, they don't have a lien, everything else goes away. And that's really my takeaway from the situation.
Thank you.
Thank you.
I do want to share with you one thing. Don't read too much into us saying we're going to go ahead and try to resolve this issue, and we didn't grant your motion to dismiss.
Well,
the purpose of that was to get this matter here for as much resolution if possible.
I understand.
And to echo what Judge McGee just said, to say that this record that consists of 32 technical records and 1 transcript is confusing would be an understatement.
If I may, and I know I'm well over time, but let me say, the vast majority, I'd say 80% of the record, relates to a recusal issue that was already determined. I think of the 33 volumes, 25 of those volumes, plus or minus, relate to recusal motions and things that were already decided by this court and frankly, the Tennessee Supreme Court. So why those were even in the record, I can't explain because I didn't compile it, but I think all those pages were frankly a waste of time.
Thank you. Mr. Rout, I believe you have 3 minutes, sir.
Yes, sir. Thank you. So, Judge Armstrong, to your point, the probate court assumed jurisdiction over the trust funds and also had assumed jurisdiction over us by ordering us to mediation in the case previously.
So did the circuit court agree to that?
I don't know that the circuit court was aware of that.
Well, I mean, that litigation was pending in the circuit court, and I'm not sure she had to agree to that, but I'm just curious if she did.
No.
Okay.
So the probate court had exercised that jurisdiction. So, we proceeded to the October hearing, and we did actually, we keep saying we didn't try to introduce evidence. We did. We did assert privilege over the fee agreement. We requested on multiple occasions, actually throughout this process, but at the October hearing and also in the March hearing, that the judge take the agreement, review it, and make a determination whether or not it's privileged. And if the judge ruled against our privilege claim, we would have produced the document, we would have had it in evidence. But as it stands, it is correct, the motion to revise is still pending. So what happened is, after, what we believe happened is that after the October 26th hearing, the court realized that it never actually held a proper interpleader hearing, and the motion to revise basically addresses every issue in this case. And that's never been ruled upon. That's outstanding. He's never entered an order on that one way or the other. Let's see.
So where does that leave you?
Well, that's a difficult question. There's a difficult question about whether or not jurisdiction exists right now in this court. But let's see. Oh, I just wanted to quickly address too, as to the argument that we have somehow waived our objection to interpleader, that's not accurate. Even though he had already entered the February 13th order granting interpleader, we ended up filing an answer because there were still issues outstanding in May or June. I can't remember which month. But in our affirmative defenses, affirmative defense 4, and our response to the introductory statement, We did object to the granting of interpleader and the entry of the February 13th order, so we haven't waived anything there. And I think that's all I have, unless there are further questions.
I see none. Thank you.
Thank you.
Counsel, thank you for your argument. It's been clarifying somewhat. We appreciate that. I know you've done your best, and that this is a difficult, confusing case. We will endeavor to get you an opinion at the earliest possible time.